the current governor of the central bank, Dr. Johnson Esiama. There was also Holder Holdings as well as other individuals who were standing trial alongside him. We heard from the Attorney General last week say that the decision had been taken that a threshold of 60% has been fixed in terms of the losses incurred by the state in relation to the financial institutions. And once Unibank met that particular threshold by way of the shareholders who were before the courts, once they met that threshold, the decision was taken to discontinue the case. I mean, that attracted some criticisms from various quarters. There are those who use the analogy that, well, someone steals 10 goats and he tells you that, well, I'm bringing back 6 and I'll keep the 4, and the AG has decided to accept the 6. The Attorney General responded directly to that particular analogy and explained why the state has decided. He makes the point that, look, there is a lot at stake in terms of the recoveries. You are pursuing a civil matter, there's a criminal leg, the monies involved in both cases are not the same, and there's the possibility that you may not even make the recoveries that you expect to make. And so that is the explanation that he put across, which has already attracted another layer of criticism from the minority in Parliament, who have threatened to take legal action against the Attorney General should he fail to rescind his decision not to continue with the prosecution. And so that is what we'll be discussing with you this morning. I want to start off the discussion by hearing from the Attorney General, Dr. Dominic Ayeni, as he addressed the nation yesterday on some of the major issues relative to the decision to discontinue the Dr. Kwabena Duffuor trial.
Monies didn't go out to anybody. These were just book entries that were designed to make the books of Unibank look good. That is how come that in the criminal case, the charge of falsification of accounts was brought against them. So they did not loot the money. They did not give the money to anybody. They just made entries that were meant to give Bank of Ghana, the central bank, the impression that the bank was doing well. Okay. Then the exclusion of 0.3 billion relating to Unibank's placement with a SEC-regulated, SEC-related company currently in receivership, which is being pursued separately through the insolvency proceedings. After prolonged negotiations, the accused persons, by a letter dated 7th May 2025, made a proposal to settle the revised outstanding obligation of 3.3 billion Ghana cedis through a structured approach. The accused persons offered to pay 2 billion Ghana cedis in full and final settlement of the outstanding obligations through the following arrangements: 800 million worth of assets to be transferred directly to Unibank, which is in receivership, which will now make that available to the Bank of Ghana. And then their active cooperation and participation to assist the receiver to recover an additional 1.2 billion from the direct beneficiaries paid out on their instructions. Out of the above arrangements, the accused persons have provided landed properties valued at 824 million Ghana cedis to Unibank. That is, in receivership. Further, in other words, indirectly to the Bank of Ghana or the Republic of Ghana. Further, the accused persons will be responsible for any shortfall in the proceeds realized from the sale of the landed properties. A total of 0.5 billion has to date been recovered out of the 1.2 billion being pursued from the direct beneficiaries. Recovery of the remaining balance of 0.7 billion out of the 1.2 billion Ghana cedis and the realization of the landed properties provided are expected to be completed over a timeline of 18 months. Although the preference would have been for me and my team for the accused person to settle the proposed amount in cash, immediate settlement in cash was not, from my sense of what transpired at the negotiations, a realistic possibility or a realistic option. In assessing the proposal submitted by the lawyers for the accused persons, I took into account the following factors. The receiver of Unibank acknowledged that the fictitious amounts totaling 2.1 billion did not result from cash outflows, but related to accounting entries that overstated the asset base of the bank, which predated Unibank's placement in official administration. I want to jail persons who have looted state resources, but at the same time, I am pragmatic enough to know that it is not in every instance that that is possible. In those circumstances, I will opt for non-conviction based asset recovery.
That's the Attorney General, Dr. Dominic Ayine there. That explanation he provided did not sit well with the minority in Parliament. Kwame Anyimadu-Antwi, who addressed the press conference on behalf of the minority, did indicate that if the Attorney General does not rescind this decision, they will consider taking legal action against him.
Ghanaians, including us, the minority in Parliament, have since been wondering the legal basis for the entry of a nolle prosequi in the suit under reference by the learned Attorney General. Has Dr. Dominic Akuritenga Ayine in the past acted for Dr. Kwabena Duffuor and Unibank? In the case of the Republic versus Kwabena Duffuor and 7 others, is Dr. Ayine now the Attorney General of the Republic of Ghana? The deputy referred to him as the Attorney General, and today he has granted a press conference acknowledging that he gave out the press release and he tries to justify why he entered the nolle prosequi. Ghanaians would want the Attorney General to explain to us in full the extent of conflict of interest using Dominic Ayine as defense counsel and Dominic Ayine as the Attorney General. Does the Attorney General have the right, in law they say so motu, to free offenders at his own discretion? The learned Attorney General has obviously forgotten the theories of prosecution and punishment. We therefore call upon the Legal Counsel and Bar Association to investigate potential breaches of legal ethics and professional conduct. May this press conference also serve as a formal notice to the Attorney General that if his decision is not reversed within a reasonable time, the minority will consider its options of proceeding to court to challenge its decision in its entirety.
Well, that's Kwame Anyimadu-Antwi there. He's a member of the minority in Parliament addressing that news conference. I want to introduce you to my guest joining us this morning. Joining us via Zoom is Justice Abdullahi. Justice Abdullahi is a legal practitioner, a law lecturer as well. Mr. Abdullahi, good morning. Thank you for joining us. Hello, Mr. Abdullahi. Okay, he will join us shortly when we establish that connection to him. Nanaya Sapon is with me in the studio. He is a senior political aide to Alan Kojo, chairman of the Movement for Change. Nana, thank you for joining us once again.
Thank you, my brother. Good morning.
I want us to start off first with, there have been 2 press conferences in terms of communications. First was a press release by the Attorney General, and the second one being the press conference that took place yesterday. Have all your questions been answered so far by the Office of the Attorney General?
Good morning once again. I believe that the students of law would still have questions to ask. The individuals who are also involved in banking and finance would also have questions to ask. And the individuals who are also students of politics would have questions to also ask. Now, once in this dispensation, the conversation has not ended, we would continue to ask questions and we would demand answers. That doesn't mean that what the Attorney General has done is wrong or unconstitutional. After a careful replay and listening to the press briefing by the minority, I was expecting the minority to have stated the legal basis, the constitutional breaches, the for lack of a better word, the where that the Attorney General went wrong. And once they were dealing with the Attorney General, it would be right, or it would not be wrong, if they went on that tangent on giving legal background to it. Now, let's take it one after the other. You and I agree that it is established in our Constitution that the Attorney General is the only person in Ghana, or the only lawyer in Ghana, that represents the country and has the powers to prosecute criminal offenses as it stands now. And so if he's the only one that has that legitimate power, then there is the need for us to at least give him the benefit of doubt that that work has been well done. When you are dealing with issues that has to do with money, in as much as there would be criminal offenses, or in as much as this is a criminal offense, for that matter, but yet involves money. As a lawyer, what you do best for your client, who is the prosecutor, is to be able to recover or take back chunk of what has been lost. And so let's bring it out of government. Let's bring it to our regular business dealings. So if you are owing me, Joe, or maybe you've defrauded me, let me put it that way, maybe to a tune of about $1 million Ghana cedis. All right. Now, if I get a lawyer to take you to court, what would be in my best interest is for me to get my monies back. You understand? If I get my monies back, I can reinvest my money. Yes, I would be happy if you go to jail to deter others from going the same way. But at the end of the day, it is the money that is important. And I have sat here and I've stated on a couple of occasions that the people going to jail, yes, exciting. I mean, it will deter others from walking that same path. But to what end? They would go to jail, come back, and then they are going to go back to the monies they have looted. They are going to go back to the properties they have acquired, and they are going to live a very comfortable lives with their wives and children and other families. But if we are able to recover them all, it will deter others from doing it. Now, the processes that is involved in the recovery is what we would say whether it is legal or not legal. If the Attorney General has entered a nolle prosequi, is it legal? Now, Joe, if you look into our Constitution, Article 88, the 3 and 4, that basically deals with the powers of the Attorney General. When I think you can have it then. It deals with the powers of the Attorney General in terms of criminal prosecution. Now, when you have given the powers to the Attorney General by your Constitution in terms of criminal prosecution, it means that you have given him the authority to gather the information he needs, to do the analysis, and to come to a conclusion for you, whether or not it is worth pursuing. And so the Attorney General, on behalf of the people of Ghana and the government of Ghana, has a right per the Constitution to continue a case, pursue a case, or to abort the case.
Okay.
Now, if you look at the Criminal and Other Offences Act, 196, all right, when you look into Section 54, where the talks about nolle prosequi, you would understand that the discretion lies in the hands of the Attorney General. And he does what we would call the risk analysis to make us understand whether it is worth pursuing it. If it is not, or if going the other tangent is what is going to help, then he would advise. What are we discussing? We are talking about monies that have been lost or seems to have been taken criminally by some others, because of course it's a criminal case. In this country, we have Act 2022, all right? That is the Act 1079, which has to do with plea bargaining, all right? That is the criminal, it's the same criminal.
It's an amendment.
It's an amendment, yes. Now, if you look at the section 162 A, 1 and B, all right, it gives you that legal principle, okay, on which I just want to be able to find it right now and read it out. And so that we do not communicate to Ghanaians as though the Attorney General just sat in his office and decided that, hey, I have called the people to come for us to discuss, and for that matter, they should just be allowed to go scot-free. So let me just...
Would you be surprised to have heard the Attorney General yesterday when he was asked directly whether they did the agreement under this new law? And he said no, the agreement was a bit complex, so they did it outside this particular new law. Does that come to you as a surprise?
I would not be surprised. We have lawyers on this table, and you have the practical knowledge of some of these cases. Joe, let us understand that the law is not static. When it comes to recovery, I have been a recovery officer before. When it comes to recovery, the techniques of recovering is with you, the person doing the recovery. You understand? Now, there are times that people would walk to the bank and tell you that, listen, yes, you are doing a recovery, I can't pay, but I have this property, all right? If the bank can lead negotiations and sell and take over. There are times people have investment in other jurisdictions and they will tell the bank to pursue it. Okay. All right, that is not in the mandate of the bank. You understand? So if he went outside of the laid down principles, it is not because it's illegal, but because that would have been the best way to have a recovery of the monies. Now, if you read the section I was talking about, a person charged with a criminal offense may, at any stage of the investigations or proceedings before judgment, negotiate and enter into a plea agreement with the Attorney General. The B says that the plea agreement entered into under Section 1 may include an agreement to pay compensation or make restitution and may result in the reduction or withdrawal of charges. And so the Attorney General has done nothing outside the jurisdiction of the laws. You understand? Now, what we should be asking, and what I thought the minority would lead, was, number one, the terms of the recovery agreement. Because in every recovery, there are terms of references. So, what were the terms? Okay. You understand? Number two, if the Attorney General has stated that he had recovered 60% of the monies that Ghana had lost, all right. Now, these are figures, numbers. You can't hide them. All right. So, Mr. Attorney General, are you able to feed us, all right, with an audited report of the 60% you are talking about? How much, okay, all right, were we to recover? Okay. And what does the 60% amount to? Number three, if the 60% has been recovered, it means it is somewhere we can easily identify. Then he gives us a proof that this is the 60% that was recovered. You get it? And that this is what it was used for if it has been used, or this is where it is seated. If it's in Bank of Ghana, then we know that it is with Bank of Ghana. If it is in a particular accounts, a recovery accounts whatsoever, or a special purpose vehicle accounts that is with Bank of Ghana, then he tells us that this is where the money is. And number four, what the future holds. Because the financial crimes are not going to end anytime soon.
All right.
I mean, in advanced world, there are always financial crimes. It is not going to end any soon. So, what is the precedent? Is it going to be something positive, or does it have a negative implication going into the future? Is it the best legal tool that we can use? Right. Do we have to go beyond this particular tool to adapt other tools to help us deal with issues of financial crimes? So this would have been the thematic areas
that you expected the minority
we expected the minority
right.
to look at. But to come and hold the press briefing just like the Attorney General did, only to wash it and will not even state on which legal principles that you are asking those questions. I mean, to me, it was nothing.
I'll come back to you. I mean, particularly on the numbers game, because Bright Simmons has done some analysis on the numbers, and he puts the recovery at 10.6%, not at 60%.
Yes, and we'll talk a bit. Just a quick one on Bright Simmons. When I read it, it was vague. I mean, I can also just sit down and say that, I mean, the recovery is beyond 60%. I was expecting Bright Simmons to have been bold enough to state the figures. Numbers don't lie. Numbers don't lie. If you bring out the details of what you think it was, all right, and where you think they are now, that would help us all. And then if he's able, once he's been able to get the figures, it means he's privy to the terms of reference in terms of the recovery agreement. So he should just lay it down. He can't just come with this very sensitive issue and come and throw dust in it and see that.
In terms of the facts that we know it, the Bank of Ghana directly gave Unibank 2.8 billion. From what the AG has decided that they are going to recover per the agreement is 2 billion. The starting point is that amount is even less than even what the Bank of Ghana gave directly. That should even tell you that on the starting point we are not getting as much as we ought to.
That's why I asked the question. I said that, are we able to know the terms of reference with regards to the recovery?
Okay.
Because what are we recovering?
Okay. No problem.
You might not, the 2.8 billion you're talking about might have certain elements that we are not privy to. So what amounts to the 2.8 billion?
All right.
What was the breakdown? And why is the AG recovering 2 billion?
Okay.
These are issues that will be raised in the recovery terms.
Okay. I'll come back to you again. Let me go on Zoom now. Justice Abdullah is on Zoom with us. Counsel, good morning. Thank you for joining us. Hello, Mr. Abdullah.
Thank you so much. Good morning.
Yeah,
good to be here.
Yes. I want to start off first by picking your brain on a question the Attorney General was asked directly about the question was whether the agreement was conducted under the Plea Bargaining Act recently passed by Parliament. He answered that no, it wasn't conducted under the Plea Bargaining Agreement because he says of the complex nature of the transaction, the civil and the criminal component. I mean, does that, as a starting point, raise a red flag for you in terms of how this transaction has been handled?
Well, it does indeed raise question marks as to the agreement was pursued and then reached. I at all times was of the opinion that this whole thing was under the Plea Bargaining Act. And so when yesterday I heard from the AG himself that it wasn't under that act, quite frankly, I was perplexed about that response. And I was hoping that he provides further information as to the law under which this agreement was reached, because that would be the starting point for questioning the legality or otherwise of it. But having said that, we need to also recognize that being a lawyer in itself for a particular client gives you the authority to negotiate. But once you're operating on behalf of the state, and the state operates within a scheme of laws, it is appropriate that at every point in time when you are acting, you give us the basis for what you're doing within the issues of the law. It's more helpful that way than these sort of agreement was reached, because common sense, everybody would have thought that this was under the Plea Bargaining Act. But of course, as I said, the Court Act allows for these kinds of negotiations on the restitutions when a criminal matter is under is being pursued. So, but that notwithstanding, I think that the AG would need to come back with further information on that, because with a criminal prosecution, and then finish the civil court with this information on the basis of which they can enter consent judgment, and for that would have taken care of both sides without having to raise these red.
Okay, I'll come back to you, Justice Abdullahi, shortly. But joining me in the studio as well, Dr. Josiah Koba, former principal lecturer at the Ghana Institute of Management and Public Administration, is also a legal practitioner as well. Doc, thank you for joining us. Next to Doc is also another legal practitioner, a member of the National Democratic Congress, Victor Adawudu. Counsel, thank you for joining us.
It's a pleasure.
Yeah, I want to start off with Doc before I return to Mr. Abdullahi on the line. I mean, Doc, the point that Mr. Abdullahi makes about the AG opting not to go under the Plea Bargaining Act. If you compare the Plea Bargaining Act and Section 35 of the Courts Act, which he makes reference to, the obvious similarity which anyone sees is the fact that under both laws, the court is involved. The agreement would have to go to the court. There are those who say it raises red flags because they say that what the AG has basically done is to have an agreement with the accused persons outside the courtroom. So there's basically no independent arbiter looking and clearing the deal as being fine. I mean, what do you make of that point?
Well, I think that the AG has told us that given the complex nature of the case at hand, he did this outside the plea bargaining rules. I think he's been clear about that. My own feeling is that he has the authority to do that. He is in a position at any point in a prosecution to throw in the towel, so to speak, or to say that we are not going to continue. I think he was at pain to as it were, tell us that prosecuting financial crimes like the one that Dr. Dufour is involved in, it's a very complicated, very complex process. And sometimes you have to make a judgment call in terms of going the full haul and cutting a deal, and assess the risks. I think that given the situation, we should trust his judgment. And after all, he is there. He's got a professional staff. There are things that I'm sure are involved that we don't know. Yes, having said that, I think I agree with my learned friend that he needs to explain. I think that even though the AG is clothed with the authority to make such deals, it is always important in a democracy like ours to explain to us, the generality of the public, how he got to where he has taken us. So I think that we should trust his judgment. And I think this is not going to be the last time we're going to see this, because it's not straightforward. You know, I was struck by his discussion of the goat thief. It's not as simple. You know, causing financial loss, for example, it's not the same as stealing. It's and these are the things that he needs to explain so that people will not be upset. I think some people are. I was listening to the radio this morning, and people are saying, "Well, the poor man steals a goat, and a rich man steals millions of dollars," but sometimes that comparison is not fair. Okay. And he needs to explain that to us, and I think that at the end of the day we have to trust the judgment and move on. You know, one other thing, you know, these crimes, these trials take a long time in Ghana. You know, you have trials that go on 3-4 years, 5 years. You know, and at the end of the day, you're not really guaranteed in terms of how much you're going to recoup. So if you can, there's no guarantee as to how much you can recoup. So if you're able to make a deal and get some money for the state, so be it. Of course, people will make their calculations. Some people will think you didn't get enough on behalf of the state. You didn't get enough for the state. Others will think that that's the best deal that you can cut, you know. But at the end of the day, Attorney General's office is a professional office. I like to trust that they did the best within the circumstances. I agree that they need to explain it to us. We need to carry us along so that we can have faith in what they are doing on our behalf.
Let me get back to Just Abdullah, and I'll come back to the studio. I'll just come back just a second.
Yes, I want you to ask a question for me. If you look at Section 162 Q, it says that the Attorney General may issue guidelines for the administration of plea bargaining. You are lawyers. What does that mean?
Well, no, the guidelines is that there must be a standard procedure if you want to have a negotiation for plea bargaining. There must be some standard that is set down, what we have to look at, the factors that will have to be incorporated into the agreement. So you issue that. It is not like every particular case will come with what the person or their discretion.
It means that the complexity of the case informs the guidelines that would be issued by the agency.
Definitely,
in terms of recovery.
Yes, so there should be some standard that everybody would be fit into it. So those are the criteria and factors that you'll be given. Okay. So that whilst you are negotiating, you look at those criteria.
I'll come back to you on that point. Let me try and wrap up here. Mr. Abdullah has an engagement, so let me just get back to you. Mr. Abdullah, the point you were making about the fact that it wasn't carried out under the Plea Bargaining Act, and the court was taken out of this particular transaction, and the AG did this agreement with the accused persons and is now briefing the public about it. I mean, the AG makes the point that if you compare this case to what has transpired in the Bates Capital Bank one, the Republic versus Mike Nyinaku, one must come to the conclusion that the goal always in terms of financial crimes is to make as much recovery as you can. And if at any point you make some recovery, it should be good enough for you.
Indeed, I do agree with that principle. And I was actually going to cite that as an example. During the week when the AG, that was last week, when the Nobel Prize was entered, I was on air to have said that considering that we stood to gain some 2 billion out of this, we have been stuck with this issue for, if you like, 6 years without getting anything out of it. So if you are getting about 2 billion of it, I think you are far better off at that than waiting infinitum. And you are not guaranteed the recovery you seek for. Let's all remember that prosecution is not a persecution of a matter that you can guarantee yourself the outcome. This is a contest between two opposing sides.
And I remember having to speak to some officers within the AG's office. And the impression I got was that even the amount that was allegedly lost to the state was not agreed on by the two sides. So each side had a different figure as to how much was indeed genuinely lost or not lost. And they had to contest that issue first off, before even coming to the conclusion they arrived at recovering the 60%. Legitimately, I agree with anyone who asks, if 60, why not 70? Why not 80? Why not 90? Why not 100? Why not even 200? I agree with that. I mean, all those asking such beautiful questions. It is indeed part of our democracy that we seek these clarifications and the basis for arriving at these figures. It is good for our democracy. It is what we need. But we should, in doing that, we should also remember that time passed, we didn't even have the benefit of knowing these information, knowing that these forms of agreements and how they were even arrived at. We didn't have the benefit of being informed as a nation as to how these things were done. So, for me, I take it as we have moved a step forward in the pursuit of accountability systems and the entire processes governing our governance structure when it comes to this bit of it. But that should not be enough. We should still ask all these other questions. But like I said, as I was during the comparison, if you relate this to the base capital, it is possible that we could have lost entirely every single amount, including the 2 billion. We could have lost it because we are not guaranteed the full recovery. So, if you look at the circumstances, you are obliged to take the best decision that inures to our collective good, rather than being egoistic about insisting on getting someone convicted when you are not guaranteed that conviction. In any case, as my brother rightly pointed out, the conviction will not serve as any useful purpose, assuming we even secure that.
Okay.
Convictions and punishment generally are to ensure, to do a number of things, i.e., serve as a deterrent to others. And of course, also seek correctional measures of the person who has been convicted, is sentenced. But the research will tell you that this basis or objective of conviction, in fact, punishment generally, has never been achieved in any country. As a matter of fact, in most instances, they end up rather bringing the unintended adverse effect. But that is not to say that if anybody does anything wrong, we should simply just let go of the person simply because you are not getting the benefit of punishment. This is to say that when you have an opportunity to make so much impact as against punishing the person without getting any benefit out of it, you have to choose wisely. And under this particular circumstance, I think our Attorney General chose wisely. Except he needs to give us the basis for doing so. And without that basis, this whole thing could come crumbling. Because let's all remember, power is transient. Today, we may be applauding the Attorney General because he has done what we used not to have. But someone else would also be in office and would want to go deeper into this because probably you want to take us to the next level. And if you open this box and do not find any legitimate basis for it,
okay,
we would have shot ourselves in the foot.
All right. All right. Just Abdullah, thank you very much for joining us this morning. I know you have some other engagements, so we'll leave it at that for now. Just Abdullah is a legal practitioner and law lecturer joining us with his views. Let me come to the studio now and let me come to Mr. Adawudu. And the question I asked Doc earlier about the fact that the AG opted not to do it under the plea bargaining agreement. And the obvious difference is the fact that the court is involved under the Plea Bargaining Act. And under the Plea Bargaining Act, the court can reject the agreement, provided it has a basis in law to do so and certain requirements under law are not met. In terms of perception, it involves a former governor of the central bank, a former finance minister, a leading member of your political party. Was it not more appropriate that that perception challenge is cured if it's done under the law for the courts to have, as some would say, the final say on this matter?
Thank you, Blay. First of all, let me just say thank you, extend our deepest gratitude to the President for visiting OT region last Friday. I'm sure he had some good news for the people of OT, and the people were so expectant and they were happy seeing the President, and I'm sure he has promised them a lot of things that he will do. And they are so grateful. I just came back from OT yesterday. At least the mood in there, people are happy that things are getting on. And they, as Oliver Twist, they will ask for more. And let me also say thank you to most of the constituents who traveled to Dambai, specifically the Akan constituency. Now, you see, the perception out there is that because Attorney General answered emphatically that this was not done under the Plea Bargaining Act, the perception is for everybody is like it was not done within the law. It does not have legal basis or the anchor. Let me tell you, the first article, and that gives the Attorney General that power to institute and even withdraw matters, is Article 88. He does it for and on behalf of government. Nobody can question him that you have done this or not, right? 2, even the Criminal Procedure Code gives the accused or litigant opportunity to reconcile. So it calls for restitution and others. It gives him that power. Again, the Court Acts gives him that power. And even in civil matters, parties, whilst they are litigating, can decide that let's have a terms of settlement, that we will settle our matter. We understand each other, we will settle our matter. And the Attorney General also has the power, which we call the nolle prosequi, and that he can at any time within a trial go to court and says that I'm no more interested in this matter. The judge has no question. He cannot ask him, why are you using the nolle prosequi? And also, do not forget that Article 21 says that in every democratic society, we need information, sufficient information for the benefit of society. Putting all this together grounds that legal basis. It anchors the Attorney General with that power that he will be able to initiate or withdraw any matter and settle any matter. So it should not be out there and says that, hey, it was not done under the Plea Bargaining Act. So because it was not done, the Attorney General in his own corner or in his chambers has gone to have a personal discussion and has come out with this. I don't think that is so. Is that nobody is saying that he does not have that legal basis to negotiate and make sure that this is done. Now, the issue was about when you file nolle prosequi, that power given to the Attorney General. You know, society has moved from some point. You don't need to even tell the populace or tell the judge the reasons why you are withdrawing the matter. But we have seen how the nolle prosequi was being used and is being abused. That is why civil society and the citizens become skeptical when the Attorney General enters a nolle prosequi. They want to find the reason why it's been done that way because of the abuse that we have seen. Because if you think that maybe I may not secure the kind of judgment I want, what I want to do, then you put it in. I'm sure that is what has guided the Attorney General this regime, and he has taken a policy decision that if I enter nolle prosequi, I will have to come and explain to society and carry them along. If I've done any terms of settlement, I need to carry the people to understand. Give them that information to meet the Article 21, listen, that in the democratic society, I give you information as to. So where it comes and says that it does not have that, I think that that issue will not stand the time of scrutiny.
How do you respond to the point about the lack of the independent safeguard? I mean, if he had even done it under Section 35, the court would have been involved. We saw that in the 2ACN1. The plea bargaining act, the same thing. But by going basically under his power under 88, he's basically said that, well, I'm satisfied, I don't want to prosecute. I don't have to explain, but I'm deciding to explain it to you.
Yes.
It lacks the independent assessment by a court to say that this agreement is fine.
No. You see, even when you go to under the plea bargaining and the Section 35, it is a proposal that Attorney General agrees and goes to court for the court to look at it and assess and says that I think this is suffice. So that is even a discretionary measure on the part of the judge. So it is not like it is the judge who would have to assess and evaluate and say, this is what I want.
Yeah, but under the law, if you take a look at 162J, it says a court may reject a plea agreement in accordance with law. In fact, it makes it very broad.
Yes, so it is the exercise of the judge's discretion.
Yes, and
right?
that's the point that people make, that because there are two parties involved and the potential of the two parties being from the same political party, why not let a judge exercise that discretion, clear the agreement, then we move on?
So are we saying that the Attorney General's judgment, when he's representing, is not personal capacity, in representing the nation or the government, that he alone will go with his personal decision and say that this is what...
Mr. Dawood,
it has been discussed.
We all know the accusations that have been leveled against the office of the Attorney General in the past. I mean, if someone raises this point, it's not far-fetched as to why the person will raise that fear.
That is why the Attorney General, they are asking that he comes again to explain what are the figures involved, what are the benefits. And I'm telling you already, he says that 500 million has been paid. Do you know what that 500 million can do? The road constructions, the feeder roads, the boreholes, the chip compounds. Do you know what that money can do for this nation? And remember that we are looking inward, that we will recover all those monies that are due to the state. That once we have those money, we will use it. Now, you see, it may seem that, yes, they are from the same political party. But as the fact remains that because we are family members do not quarrel, they do not disagree. So it means that once we are all NDC, there's never a quarrel between even we. There's no misunderstanding. There's nobody within the party who says that, look, we must live with principles, we must live with integrity, we must live with credibility. So it is like, excuse my language, my French, everybody within NDC has the same pattern of thinking, thought processes, that what we think, that is how we go. No. Okay. We debate. And this matter, before it is settled, I don't think Attorney General alone sits down. Cabinet, important senior members will sit down, of government will sit down and look at the vis-a-vis, especially with the precedents that we've had. When cases came up, and at the end of the day, because they wanted that, look, we want to move on, let's bring closure. So they said, we want to come and negotiate and bring you some money. Example, the current finance minister, Jakpa, there are people in that case offered to, make some payment for restitution. The Attorney General refused to, right? There were other cases. Let's say, apart from that, there was this Yineku
the big one, which the AG made reference to.
The AG made, right?
So he said an offer of 10 million was made. He decided that, he's not going to take it. Now the Court of Appeal has acquitted him.
Has acquitted him. Yeah. So have we lost?
And they will soon discharge him.
Yeah? Yes. Have we lost or what? So, you see, based on that precedent, and, people are no more interested in that, partially that he's been punished for the offense. And no, you must note that when it comes to criminal matters, you are not supposed to be taking money and say restitution. That is not the foremost objective.
Okay.
The foremost objective in criminal matter is to punish you so that it becomes deterrent to others. But now society is changing. Society is saying that, look, we can't punish you once you have the loot and everything. You go and serve sentence and come back, or your family people should enjoy the booty. We, the society, wants to have our money back. That is where we are getting to. And that is where what is guiding. That is not to say that people will not be punished when it is seen that it was intentional, it was willful to indulge in criminal enterprise. Right. So those are the things that has guided the Attorney General.
Okay.
What I think is that whether the amount is 2 billion, what was the first most objective for the money that was given to Unibank? It was to resuscitate the company, the institution, resuscitate. We are not in to kill and collapse the businesses. And I'm sure with these negotiations, there will be some kind of respite or reprieve for these companies to be resuscitated. At the end of the day, is it Togolese or Nigerians who are coming to work in their bank? The Ghanaians will be employed. So it is all in the bid to resuscitate and see how we will be able to bring these institutions back. People died. A lot of people died in this banking cleanup exercise. People lost their money. Yes, it is gone. That chapter with this. But if we are starting and Unibank is able to come back, we knew what they were able to do. Yes, we have also recognized that there were some few, I don't think the directors just sat down and said, cook their books. Maybe there were some few people among who feels that, look, this is a way we can do to shore up our capital or present to the public that we have the standing, we have the financial muscles, which at the time before maybe it gets to the board who would give the strategic direction, the harm has been caused. But you see, so there are things that happen, and as it had happened now, I'm sure that the Bank of Ghana has taken some controls. The new institutions that will come up will make sure that we follow the guidelines. So I think that on the whole is a good thing. Now, the last allegation I think the minority is making is about conflict of interest.
Okay.
You see, we are lawyers. Anytime, maybe you've represented one client before, and in a different matter, you are against that client. I don't see that as a conflict in a different matters. It's a conflict of interest. But because we just say, oh, because you have represented him before, it's a conflict of interest. It is when you use information that client you had represented earlier, information to his disadvantage, which is injurious to him, that he confided in you on information, and now on the opposite side, you are using that information to his detriment. That is what is the conflict of interest. You know, I've had issues with some judges just because, even in criminal matters, I was representing a group of them about, let's say...
I know that.
Yes.
I know that.
And once we had some disagreement, I decided I was not going to represent about 2. They said it was conflict of interest to even cross-examine or ask questions. When, you know, the information that I have is not injurious to their, but I just left it like that. Okay. So it is like, even to extent that when you see judges and even lawyers who are doing cases before them in a restaurant, they say there's a conflict of interest. So now we know everybody. And I always tell people that they should read the case of Salah. Salah versus Attorney General. We live in a community. Everybody knows your parents. You know your parents, know your background. We've been classmates. We go to the same church. Does that mean that when the law imposes a duty on us, we will not do our work? Does that mean we have lost our integrity? Does that mean we have lost principles that we come in and so because I know him, we go to the same church, I'm going to lower the bar?
Okay.
I'm going, no, that's not it. So when they come and say, oh, the Attorney General, his firm has presented Dufo before. So
in fact, it was only on the first day, the arraignment day.
Yes.
That was the first day.
Yes. You see, so I think that let's go deeper. Society wants to be educated. Let's guide society. Let's shape vision. Let people understand, but not going by and say that, look, we're mudslinging, we want to slant and say that. And I'm happy the minority says they will go to court. They should go and challenge Article 88. It doesn't resist.
I thought that matter has been, the Supreme Court dealt with it in their FOCO matter.
Yes.
dealt with.
The 88, the powers being given.
So, no, that's why when they said they will go to court, it is for the optics. It's for the people who do not understand the tenets and rudiments of the law and say, oh, my people are going to court.
Let us agree that this case is a matter of public interest and it is politically sensitive. And any political party or political element who wants to play mischief would definitely want to capitalize on these matters.
Exactly.
And that is why communicating these matters out there is very important. In matters like these, the elements of absolute transparency, all right, accountability, fairness, and unambiguous communication is important.
Yeah,
You get it.
I think that, in all fairness, in our recent history, we have not had an attorney general.
Oh no, I'm coming to that. I'm coming to that point.
Yeah.
I'm coming to that point. No, it's not the transparency as in him trying to deal with the matters or briefing, because we are his employers. You understand me? We are his employers. We have employed him. So, and it is important for him to brief us at any point in time. But he will briefing. When he was speaking, when I was watching the series, what came into my mind was that some political elements would want to play mischief.
Yeah.
All right, because the Attorney General probably was not willing to bring out certain details for this, for this, because there would definitely be an agreement for the recovery. All right, if he had actually put the agreement out or made clear the terms of references in the agreement, I do not think that the minority would have had any locus, all right, in holding that brief. If he had been able to pinpoint to us the 60% which has been recovered. And of course, if you look at this Atu Asian case, where the gentleman is in custody now, to what benefit is it to Ghana?
Waste of talent.
To what benefit? Did he make attempts to repay the money?
In fact, he's repaid some of the amounts.
He had
went
repaid,
under Section 35.
I think, 100 or so million. I think it was with 90.
Yes, about 90 left.
90 or so. Then I think they said that he could not meet the timelines in the terms of the agreement.
No, he could not meet the plea, what they bargained.
Yeah, what they agreed
oh,
to
no,
pay.
he was supposed to pay installments.
There were the payments.
Installment. He agreed that I can pay this sum.
Yes, in fact, he made that initial payment, but the subsequent
payment was what he made.
That's
what I'm talking about. He couldn't meet the timelines.
Yeah.
You understand me? But he being in jail, and after how many years? I don't know. I've forgotten the sentence. If he's in for 5 years, 10 years, whatsoever years he is, to what benefit?
I want to ask you something.
You see, plea bargaining. There are advantages, merits to plea bargaining. One, you already have a congested prison system. You understand me? Number two, the issue about plea bargaining is to reduce the risk of losing your matter in court. So if it has to do with financial crimes, across the world, they do not just go into court to litigate just because they want to make a case. No. It is the monies that have been lost that you want to recover.
Yes. And
once you have recovered, some even go ahead that aside the recovering what has been lost, they take in additional monies. You understand me? At certain jurisdictions, they confiscate your properties.
Yes.
and bring you back to square zero.
Yes, but Nana, in some of this, during the plea bargaining, for criminal enterprises, you want to find out the loopholes, the modus operandi, how they were able to do that, to siphon money
Of
or
course.
to launder money, right? So once you get these controls, you know the modus operandi.
That was used.
It is for you. So it's also part of the plea bargaining.
Yeah, of
That
course. I
once
mean, it's
you
part of
understand
the-
and you mention the people involved. You know, what's
it's
the
a network,
cartel, the
because
network,
it's not one
then
person
we
who
are
does it.
able to break that network. So
That's
the
all.
information,
The information
that
is
it's
important.
even you have may be worth more than the money
and you see,
and the rest you are looking
the
for.
information
Because that
before-
information will help you to nip in the bud what will happen subsequently.
Just to add to the information
See.
Mr. Dufour would give, Dr. Dufour would give to the Attorney General and the National Security is of great importance and an asset to the nation. Why? This man has been a finance minister. He has been the governor of the central bank.
Wow.
He has been in the financial industry for a very long time. He is in depth. He has so much knowledge when it comes to financial issues. And so if you have such a person involved in the plea bargaining and giving you all of these details as to how these things happen, in fact, it can even be used, the information he will give can be used to guide and help the consultants who are going to be employed to deal with the managerial gaps in most of these financial institutions. You understand me? I do not think if we had sat aloof and watched ADB and NIB sold, just like they wanted to do, we would have been here today. ADB has been saved today. Why? Because some external persons got involved with their skills and knowledge, and they helped the management gap that was there. The hotels they wanted to sell. Today, these same hotels are making profit. Why? Because of the use of knowledge and information.
Okay.
And so if we have been able to, what is most important is the AG to just come out and tell us that this is the amount that was.
But it's not everything.
But also,
You understand?
The information is priceless.
I think that politicians have a duty to understand. They have to know that when we politicize, like the job of the AG, we only feed into the distrust, the average person out there has for the criminal justice system. These press conferences fits into the idea that rich folks have a different standard, when it comes to.
Yeah, man. The question that is being asked, if you listen to everyone, even around the table and even on social media, anyone in support of the agreements, they analyze it in a half a loaf situation, like more or less. But those against it will tell you that it is our money that, in the opinion of the state, has been lost. So how are we doing the analysis on the basis that, we've gotten some back?
Well, this morning I heard someone say, if we don't get to take any money, just jail him.
Yeah.
But
there are those who have made that point.
Yeah, but you see, we voted for a government to come into power and look at the totality of our circumstances and make the best decisions on our behalf. I don't think it's the best decision just to throw people in jail and let them keep the loot and then and enjoy it when they come out.
And their generations.
So we need the money. It's not like we are recovering the money. And so I think that
would I be? Is it? I know, but not as a fact. But I know that lawyers, you do what we call the case risk analysis.
Yes,
You sit
definitely.
down to look at the risk involved in either you going to court or you going into an arbitration whatsoever. If the terms of contracts that's not stated clearly.
Yeah.
You understand me? And so if the AG has had an experience of losing money in a similar case, do you think that the AG would want to pursue or use that same strategy to go into court but will not revive his notes?
And that is why I'm cautioning, political actors to think more broadly than the next elections. I think these, every time there is a press conference from the AG, there should be a counter press conference to try.
That is what we have chosen.
The final question.
But this is not constitutional democracy.
The point you made on the trust and the comments that people are making. How do you think the AG should manage it? And I'm asking this question because of the campaign in December. I mean, there was Operation Recover All Loot. I mean, all loot. Yesterday we heard him say that, well, it doesn't mean that in all circumstances you have to recover all loot. Public perception is very important. In the last 6 months, they have seen the AG discontinue a number of high-profile cases. The Saglimi one is one of them. There's this one. Then they make the point that you look at that in the context of what you are doing, and they will say that, how do you carry the people along? Give them confidence.
I will answer this question broadly. Me, as an educator, I think that generally we are not doing a very good job in terms of carrying the masses along. Whether it's in law, insurance, lots of Ghanaians don't like to take insurance, for example, because they say the insurance companies don't pay. Whether it's true or not, it's just a perception out there. I think lawyers, for example, we should do a better job trying to explain to our clients, for example, or to the general masses, how decisions are reached in court. I think that generally people should understand how these things work. And I again, should pat the Attorney General on the shoulder for what he's done so far. Now, I haven't seen any Attorney General in in our recent history come out and explain what is, he might not do enough, he might need to come back to us, but he's doing a lot to educate the average person, on why he did what he did.
Okay.
Blake, I'll not shy away, and I will not mince words. Some of those high-profile cases we have seen, right, has political undertone. It was highly politically motivated that were put in the court's domain, right? The court is only there to assess the kind of evidence they bring. If the evidence inures to your benefit, so be it. If it goes against you, so be it. However, people who were being used as witnesses and others were political appointees, entities that were being used, right? Didn't we hear of the Japa? If Japa did not have that courage and temerity to record what the Attorney General had said, which would be a blot on his career, would he be able to speak and know? All of us who have believed that truly this was what had happened, but for his courage to record him tells you that, was it not political? It was highly political. Opun's case, was it not political? Dr. Ampoma, who was even brought, at the time he was working, they brought, and he was now working as a presidential staffer, all fabricating the stories. So if the system comes and says, look, for once, let's speak the truth. You have planned to put somebody to railroad him into jail. And looking at the facts, getting the facts we see, we don't think that this is something is worth pursuing. So if it's from, look, Afoko's case. Afoko's case, is it not a political thing? It doesn't come from NDC. It was highly political. Just because his brother was the chairman and has been suspended. You see?
Not has been suspended, had challenged
the system. And the system is like, look, no. So let us speak the truth. Let us speak the truth. It doesn't matter whose us is God. They were political, and if there's a political issue, it needs a political solution. Okay. If it's a legal issue, it needs a legal solution. So I think that the Attorney General over there advises government. He's the principal of the state. While he saw that these are political things, he will tell his government and say that, look, these are the political undertones, things I have seen in this matter. I have that law gives me that power to say that, look, I'm no more interested in it. Okay. Why is it that they could not? Those political cases were dragging on. You change. I've suffered those detention who went to jail for a coup plot. If I tell you the kind of things, and you know, go and read Agojo's book. Military officers, others, just after interview, then the next thing is the AD come to the president. People have been promoted. A lot of things have happened. So you look at some of this and say, why is this political for government to look good? Yes, it is past and gone. Okay. But we are not interested, and it has been discontinued. Okay. And I think we should commend the Attorney General and the government for taking the bold decision and say that, look, enough is enough. We can't punish innocent people just to have glory, or we write on that to get to the top, to get to the power we want. Right. No.
Okay. Let's do some messages and wrap up on this discussion. This one here, good morning, Joe. The adage that half a loaf is better than none. Imagine jailing every criminal in our overcrowded prisons, and the state is struggling to adequately feed inmates. It's better to collect state assets than losing everything. The MPP should have, within their 8 years, successfully prosecuted Dr. Kwabena Dufo. The NDC promised to recover all the loot. That is coming from Stephen Kwen from Wa. Musa Batua from Asawasi, you say that the MPP is making a storm in a teacup. When it suits them, it's acceptable. But when it benefits others, it suddenly becomes a taboo. Their behavior smacks of hypocrisy and dishonesty. How can they justify a nollie prosecutor for a foreigner like Aisha Wang without any explanation, yet criticize Dominic Kayini, who not only explained his decision, but also recovered 824 million. It's actually more than 824 million. 824 million is just one part of it. This is the most accountable government in our history. And instead of applauding such transparency, the MPP is acting like a child sneaking meat from their mother's soup. Final one here from Kwablavi of Pokwasi Benghazi. You say that the NPP government also quashed some cases which involve NPP members. If court has quashed Dufour's case, it is not a new thing. NPP doesn't have any power to direct the courts how to handle such cases. And so that is it by way of our first discussion on this particular matter. We know that quite recently there's been petitions being sent to the presidency asking for Atuesian to be granted a presidential pardon. I'm sure that is a question that some may consider putting to the Attorney General at some point if opportunity arises, particularly given the facts, the recoveries, and what is happening all around all of these matters. And so this is something that we'll see how it all plays out. And so that is it by way of our first discussion. I want us to briefly do an update on the Boko situation, and joining us for this particular leg of the conversation, Professor Kusienin is a security consultant, security analyst, and lecturer as well. Professor Enin, thank you so much for joining us this morning.
Thank you very much. It's a great pleasure.
Prof, I want to start off by finding out from you, for the ordinary Ghanaian, the question that is on the mind of many is, would we find an end to this conflict that, if you just do a simple Google, there's so much material on how long it has dragged? Is there an end in sight? Should we be hopeful of an end in sight anytime soon?
I think to be able to give you an answer, it will be necessary for us to do some retrospective conversation as to how we've gotten to where we are, if and how the conflict has transformed over time, who the actors are, and the dramatic shift in the operational strategy from until a couple of days ago, what has been described as peacekeeping to peace enforcement. Because I certainly did not know that what we had been doing earlier on amounted to peacekeeping. So I cannot give a yes or no answer. And well, I can, but your listenership might find it difficult to appreciate why I draw the conclusion that I draw. But let me also plead with you that whoever writes your online story must listen to the tapes very well. And if they don't understand some of my positions, to come back and not to draw conclusions. Because I did an interview yesterday with one of the major stations, and the writer, either deliberately or otherwise, misrepresented my statements concerning the shift from peacekeeping to peace enforcement. Let me make it clear that the decision to enforce the peace, that is, if there's any peace, is the right one. The authority of the Republic of Ghana has been challenged consistently, and I'll come to that. And it is the responsibility of the Commander-in-Chief, together with his military advisors, to make the necessary decisions. And I think the decision to enforce the peace is the proper one. That we need to demonstrate that the Republic of Ghana has the firepower, it has the experience, and now the political will to take the fight, first militarily, secondly economically, thirdly socially, and then to win the communication battle also. And that this multi-dimensional effort that started probably yesterday is a shift, and a qualitatively different shift in the approaches that we are going to see. But having declared a peace enforcement, having seen what the mandate is, means a whole different ball game. That ball game, the new ball game, means that we are moving from what has been described as peacekeeping, that relates first to consent amongst the different parties, although there's never been any consent amongst anybody. That's number one. But also that there's impartiality, that the police service, the Ghana Armed Forces, and all the statutory security services who were deployed to Boko were impartial to all the different identified factions. That impartiality then results in a non-use of force, except in rare cases where they need to use force to defend themselves and to protect their lives. So if you remember, a couple of, probably 2 weeks ago, there was this military convoy shielding and protecting people from Bolgatanga who were attacked, in which the attackers used basically guerrilla-style tactics, taking shots at the military convoy and then very quickly escaping into the surrounding spaces. What under peacekeeping the military are allowed legally to do is to defend themselves. And I think in that defense, some people lost their lives. The shift to peace enforcement tells us one thing, that the military and the intelligence services threat assessment of the way the Boko crisis is escalating means that we need to enforce whatever peace is there. What peace enforcement means in practical terms and for the purposes of your listenership is that now we are going to use military force. So although we have the Otumfuo mediation process still going on, in and around Boko and where the conflict has gotten to. Any identified groups or individuals who are part of this conflict or are benefiting from the conflict and refuse or dare to challenge the authority of the Republic of Ghana, represented on the ground by its armed forces, will be met with appropriate force. The second aspect of a peace enforcement mission is that coercive strategies or measures will be used to maintain or restore peace. Okay. What it means is that any act, either orally in which you intend to incite, to mobilize, and to act in ways that undermines the peace, the stability of that area, will be met with coercive force. But even more importantly, any action that is interpreted as threatening the peace, breaching the peace, or is perceived as even a potential act of aggression, will be met robustly.
Okay.
The essence or the sum total of these actions is that people must comply with the orders that have been issued. Now, because the Republic of Ghana previously allowed this conflict to fester and to transform and to get different factions, be it political, economic, social, whatever you want to call it, to think that they can challenge the authority of the state, we will see people being maimed, hurt, and possibly losing their lives. So I will appeal to the PR section of the Ghana Armed Forces to start some education process. And that has multiple benefits. One, to send a signal to the factions that we will deal with you if you misbehave, but also to prepare our minds, that this is the new strategy.
All right. Thank you very much, Prof. We'll leave it here for now. I mean, this is a conversation that we'll be following closely depending on what comes up, and as and when we'll come for some more perspective. Thank you very much. Professor Emmanuel Kwesienen is a security consultant, analyst, and a lecturer as well. Let me just wrap up here in the studio. Brief comments. Let me start with you, Doc, on the Boko situation.
Well, when I think about what's happening in Boko, my mind goes back to my graduate school days. I was in Canada. You go to a party and you see why we should cherish why we are Ghanaians. People from the north, from the Volta region, I was from Sekendi, and we were Ghanaians as compared to others from other countries who could not gel. This is something that we've taken for granted. Fast forward to the many, many chieftaincy disputes that we have in this country. I think it's about time that we realize that historical situations evolve, and that the Boko issue is not the same as it was in 1957 or 1968, that we are evolving, and that we should evolve, in terms of the solutions we find. I think Prof has given us, quite a brief on how to approach it. I think, for example, that someone who works very closely with traditional authorities, I think that aspect of our constitution that leaves chieftaincy affairs in the hands of traditional councils and House of Chiefs. It's good, that we want to have a hands-off, But I think it's time to begin looking at pulling that system into our mainstream legal processes. A lot of traditional councils don't even have qualified lawyers to advise in terms of how they, settle disputes. Yeah. And so I think that we need to do a better job holistically, generally, and how we approach conflicts that emanate from traditional systems like we have in Boku. Okay. For the people of Boku, I think that, I am very worried, for example, that now we have attacks in schools, and now it's spreading out, there are killings in Kumasi that are supposed to be related to. I think it's enough, and I totally support Prof. Eni's suggestion that the army should, our military forces should up their game, and people need to understand that we are going to have to manage this, and in managing it, we'll need to keep the peace by any means necessary.
Okay. Council.
When it is Boku, in my younger days, I had the benefit of schooling and doing some work in the north. So I knew Boku very well. We used to pass there to Sankase. It was a commercial town. But today, Boku is a pale shadow of itself. One of the questions maybe I'll throw to the indigenes of the Boku area, the Kusar and the Mampusis over there, is that do we want to see our town to become a ghost town? Is that the end objective that we have? That this is more fratricidal and matricidal conflict? Do we want to kill our own kin and kin? Are we, just because there is anger, there's misunderstanding, which has now been fused with political and chieftaincy issue, we want to kill each other, and now what anger we have as parents cascades down to the children and to our grandchildren? Is that what we want? Is that how we want to live? That at the end of the day, we would say that there was a town called Boku, today it is no more. There was a town called, all those, the Zebila, Binduri. We have our classmates, we have others who are working there. I think that when this question is in the mind, that what does it benefit us if I kill my own kith and kin? Just because of chieftaincy, because of political issues, we kill each other. Yes. You see, all hands are not equal. We may not be perfect. I always say sometimes before you get justice, there must be an injustice. Yes, injustice is being perpetrated. Others feel offended that there had been injustice. But does that all solve this problem? What benefit will it come? Sometimes I hear Boku, we have lovely people who come from Boku and its surrounding. Very nice people. And I find it difficult that these people cannot really sit down because of the tribal issues. And they can't sit down and break bread with their brothers and say that, look, we have fought. This has continued. We are maiming our own people. We have buried our own people. Why should this continue? Okay. I think that what like Professor Eni has said, if the dialogue is not working and there must be peace and its enforcement, I think that roadmap should be put. Sometimes when it is being put, they say it is not humane, we are infringing on human rights. But there must be that peace for people to enjoy their existence, the purpose why they have come. Okay. Then from that peace, they can see themselves like socially mixed and see that we are the same people. There are intermarriages. Somebody's father is a Kusasi, the mother is a Mampugu, and Bisa. Why? We are the same people. And at the end of the day, and you see, whilst this is happening, we are allowing some miscreants from the neighboring border towns and others to also come in. And once they have come in, they would benefit from chaos. They will benefit from the strife. I think that let's give a peace a chance. They are very learned people. They are very experienced people, the chiefs. Let's learn to forgive our siblings. They have wronged us. It is bitter. We may be bitter, but it gets to a point to say, look, you know what? I've seen you are remorseful. I'm forgiving you. I won't do it. I think that is the way we should get our people into it. We should not sit down. We have a regional peace council. Yes, they may be doing their own work. It means that they must do more. And as he said, I think that to stabilize things, it should be military that should enforce it first before we get the other people coming in.
Nana, final word for me.
The peace enforcement mostly is the use of military force. And I think that, in my own view, that we had waited far too long. I think that we have pampered the actors that are involved in the Boko conflict for far too long. Let us call a spade a spade. Boko is made up of about 440,000 plus individuals. They cannot hold the entire country into ransom for so many years like this. You understand? Listen, we have come to a dispensation where the people would have to understand that Ghana is bigger than they are. They have challenged what the actors are acting with impunity. They are doing it with disrespect and dare to authority. You understand me? And if you dare to authority, I think that authority must tell you that I am in charge. We have gotten to a point where the people and the actors should know. Me, personally, I've come to a conclusion that it goes beyond just land and chieftaincy. You understand me? It has an economic undertone because there are people who are doing business with conflict. And if these actors are identified, they should be dealt with anyhow, anywhere. I don't know the expression to use. Means possible. These actors have benefited for far too long, and we just have to call a spade a spade. It's not just being fueled by politicians as they want to claim, but we have the businessmen who are fueling it. We have the missionaries who are fueling it. Of course, Boko is a border town, and there is an easy access by elements from the Fulani areas, from the Musi. People are not Ghanaians. And they also kind of benefit when there is these conflicts. And so, Barbara, I think that the military, once they have taken over, that's fine. They should enforce it. The peace enforcement does not do away with the actions or the means which is being used by Otumfuo to settle the matter. But when the roadmap is drawn by Otumfuo, definitely there should be an act of enforcement. And that enforcement should be done now.
All right. That is it. All time will allow us this morning for our discussions. Nanaya Osapon is the one you just heard. Senior political editor Alan Kojo Chairman. He was also joined in the studio by Victor Kojoga Dawood, a legal practitioner, member of the National Democratic Congress. Across me, Dr. Jose Akoba, legal practitioner, former principal lecturer at the Ghana Institute of Management and Public Administration. Justice Abdullahi joined us earlier on. He's a legal practitioner and law lecturer. And Professor Emmanuel Kwesienin joined us for this particular discussion. That is it by way of a big issue. There's more to discuss on New Day. Stay tuned in.
Every day.